So today we're here to talk to you about aggregation and what that means and how you have to make a determination on whether or not certain companies are really going to be considered as one company altogether, or if they can be broken apart based on control issues or employee counts or location, or how best to determine these companies' eligibility. Hi, my name is Rebecca Shepard. I'm a tax attorney here at Frost Law, and I'm here with my colleague Peter Huckabo. We are here to talk about the employee retention credit and aggregation. Now, before we get into the employee retention credit, let me just give you a couple minutes of our background, where Peter and I have been tax controversy attorneys for about 25 years together. And prior to the pandemic, we worked with small businesses and nonprofit organizations to make sure they were in tax compliance. So we played tax defense with the IRS and state taxing authorities. Now, when COVID hit, we knew that we had to dig down deep into the CARES Act and make sure that our clients were going to be protected. So first we started with PPP, and then we worked with the employee retention credit and EIDL and RRF and all kinds of acronyms to help our clients stay afloat. Now, in the beginning, you couldn't use PPP and ERC together, and so we mostly focused on PPP. But in December of 2020, Congress changed its mind and said you could actually use these two programs together, you just couldn't use the same dollar twice. And it changed everything for us. We started looking at our clients to determine whether or not the companies were eligible for the employee retention credit. Once we determined their eligibility, we filed on their behalf. All of their liabilities were offset due to the credits, and some even got more refund on top of their offset liabilities. And since then, Peter and I have been on this informational campaign to educate small business owners regarding the employee retention credit and other ways we can help them with COVID relief. So today, we're here to talk to you about aggregation and what that means and how you have to make a determination on whether or not certain companies are really going to be considered as one company altogether, or if they can be broken apart based on control issues or employee counts or location, or how best to determine these companies' eligibility.
You may have seen, we did a video about audits related to ERC, and that video was largely focused on eligible employer analysis and what an auditor may get into and work through issues there. What we're talking about here has impact on that as well, but this is going a little bit deeper. So, like Rebecca said, there are situations where even though businesses on paper seem that they are separated through their structures, the IRS has existing code that Congress pointed to in the CARES Act and in the subsequent legislation to, in effect, pull these things together which otherwise seem separate. And that is through controlled groups of corporations and affiliated service groups. And what we are finding in doing this work is that not everybody is paying attention, especially to brother-sister controlled groups of corporations, and understanding who owns these businesses, what these individuals also own, in addition to the business that may be in front of a preparer and trying to analyze eligibility and the like for ERC. So the big one, again, is brother-sister controlled groups. It is a two-part test, and in order to establish a controlled group, you need to have both a controlling interest and effective control. And the controlling interest test generally means that 5 or fewer individuals own at least 80% of the stock of each corporation. And the definition has changed a little bit here related to this analysis in ERC, so make sure that it's at least 80% analysis for the controlling interest. So the second test then is establishing whether or not these same 5 or fewer individuals also have effective control. In that situation, you need to have a more than 50% interest in the business across that ownership group. So in working through these examples, imagine there are 2 corporations. One, Adams Corp, the second, Bell Corp. And there are 4 individual owners, A, B, C, and D. In Adams Corp, A owns 80%, B owns 10%, C owns 5%, and D owns 5%. In Bell Corp, A owns 20%, B owns 50%, C owns 15%, and D owns 15%. In this situation, the controlling interest test is definitely satisfied. These same 5 or fewer individuals own 100% of both companies. However, in this situation, the effective control test is not satisfied because the identical interest across the corporations is not more than 50%. A only owns 20% across both corporations. B only owns 10%, C and D only own 5%. So in this situation, you only have 40% effective control. Again, it needs to be greater than 50% to establish a brother-sister control group. To make matters even more difficult, it's not just enough to know who owns the business and what businesses they own. It's also important to know the relationships between the business owners, because there are family attribution rules which can change percentages and what someone is considered to be owning. So in understanding and doing the analysis for brother-sister controlled groups, again, you need to know if people are spouses. You need to know if there are parents. You need to know if there are children. And interestingly enough, you need to know if these individuals have minor children, and not just under 18, but 21 is the threshold.
Other things that need to come into consideration of whether or not companies are going to get all rolled in together, if you're going to be able to break something apart, are the family attribution rules. Typically, people don't assume that their husband or wife has any ownership interest in their business because they aren't involved in their business, but the IRS doesn't always agree. And so it's always assumed that your spouse is 100% owner in your business unless that spouse has no relationship with your business, meaning not a manager and doesn't do anything to manage the operations of the business and does not work for the business. Unless those spouses have a minor child and the IRS considers minor to be 21 and under. So for an example, if Peter and I each own a business, I own a bakery and he owns a guitar shop, I don't do any work for his business. I don't help manage the operations of his business. He doesn't do any work for my business, doesn't help manage the operations for my business. Those businesses are looked at separately. However, if we have a 20-year-old child, then that 20-year-old child is going to be a deemed owner of my business, 100%, and of his business, 100%. And that means we have similar ownership, which means that is now going to be rolled in together. It doesn't seem that complicated until you actually get into the nitty-gritty of this stuff, and you want to make sure that you are talking to somebody who has the experience of pulling apart these businesses and looking under the microscope to make sure that things are being calculated properly.
The reason all this stuff matters is that the IRS is going to consider the controlled group as a single employer for certain purposes of the employee retention credit. One of the big ones is whether or not it's going to be considered a large employer, again, for purposes of ERC. The IRS defines a large employer as, on average, an employer that had over 100 full-time employees in 2020 or over 500 full-time employees in 2021.
To determine the employee count, the employer is going to look at the first month of the year in 2019 and add up all the employees that worked more than 130 hours. And they're going to do the same thing for February, March, April, May, and so on, and then take an average for the year. Now, if you've got more than one company, then you need to do that for each company that is part of that controlled group. And this is really important because if there's ways to break apart your control group, it's possible that you're going to have additional qualified wages, which is going to increase your credit. It could also go the other way. And it's important because you'd be putting these companies together, in which case you've been filing for the employee retention credit for 2020 on wages that are not qualified. So to determine whether or not you've got qualified wages is important because that's how you calculate the amount of the credit that you're entitled to. So the first step of eligibility is to determine whether or not you're an eligible employer. Once you've determined that you're an eligible employer, then you go to determine how much qualified wages you have for 2020 and for 2021, or for the period of eligibility.
Another reason this is important is how you think about whether or not the employer, again, the entire controlled group, experienced a significant decline in gross receipts. That is defined in 2020 as a 50% decline. In 2021, it's defined as a 20% decline. But you have to consider the gross receipts of the entire controlled group, not just, again, of the employer that maybe you're evaluating. So another reason this is important is because it changes the way to think about whether or not an employer, and in this scenario, the entire group, the entire controlled group, the brother-sister controlled group, the parent-subsidiary controlled group, the combined group, whether or not it experienced a significant decline in gross receipts. You cannot just pick one constituent member, evaluate that, say, oh yes, they're eligible for the employee retention credit, go look at their qualified wages file and move on. The analysis is much more in-depth, and you cannot, by definition, ignore that. Gross receipts generally is dollars in the door netted against only refunds and allowances, but it's got to be across the entire control group. So if you have these companies that seemingly or on paper are separated, but you go in and whether it's through a family attribution issue or just that brother-sister controlled group analysis are considered a control group, there is no exception to this. You have to consider it. Congress references Section 448 in the actually text of the CARES Act and the subsequent legislation here.
So what happens if you have more than 500 employees, Peter? Are you just out of luck?
So whether you're triggering the 100 employee count or the 500 employee count, what happens mechanically is you are changing the definition of qualified wages to only those wages paid to someone who is not providing services to the employer. That's not unheard of, but it is unique. You know, we certainly see people who were paying folks to stay home because they were key talent and manager level. They wanted to retain those employees, and so they continued to pay wages even though they weren't providing services to the company. That is something that if you are triggering these 100 or 500 employee counts, you've got to dig in and take a look and see if that's an option, because those remain qualified wages even for large employers.
So again, you're paying somebody not to work, essentially. So if your business completely shut down and you felt like you wanted to not have your employees go on unemployment and they didn't work either completely or they only worked 10 hours a week instead of 40 hours a week, and you paid them for the time that they did not perform services, that they did not work, you are going to be able to claim those wages if you're an eligible employer.
So just to drive home Rebecca's point there, this is not a cliff, right? You can pay someone to provide services on a paycheck. You may also pay them not to provide services. So you could have a scenario where maybe you paid someone 10 hours that you actually needed them, but because they worked in your business for a long time or you just wanted to do the right thing, you paid them an additional 30 hours to get them up to 40 hours. You know, those 10 hours where they're providing service for a large employer, those are not qualified wages, but the wages paid to someone who is not providing services during that time, that 30 hours could be a qualified wage or is a qualified wage for ERC for a large employer.
So as you guys can see, this stuff gets really complicated really quickly. We feel it's very important to make sure that you are getting the best advice that you possibly can, and to ensure that your large company or companies or small company for that matter is doing the proper analysis to properly claim the employee retention credit. As you all know, I'm sure you've all gotten 38 text messages just while you're watching this video about the employee retention credit. There is a lot of noise in this space. There are a lot of, I'll say, less scrupulous companies that have kind of popped up out of nowhere. Make sure you're doing your due diligence on who you want to work with and who's doing your analysis to make sure that it's correct. You know, Peter and I have been doing this for a really long time now, and I won't say how many hours we've put into this, but it's thousands, to make sure we understand exactly what the right answer is and how to properly evaluate a claim. We're pretty much like Def Leppard in 1987, where we are never going to be as cool as we are right now. And so we are happy to have a conversation with you. If you've already claimed and you just want to run something by us, give us a call. We don't mind. shoot us an email if you're a CPA and you've got questions. We just want to make sure that people are doing this thing right and we're able to talk about something that we truly do enjoy doing and we've been doing for a while now, and give us that opportunity. So we look forward to talking to you soon. Thanks.
I hope if you've watched some of our stuff online that you realize that this stuff is hard, and it's not a situation where you answer a couple of questions online and poof, you're eligible and you're getting millions of dollars. This is an ongoing conversation with taxpayers that they need to understand all of the issues related to this stuff, because it is built on existing tax law. Tax law in general is complicated and convoluted, and this is absolutely no different.